Paul Skalnik never needed a weapon to destroy someone's life. He needed only three things: a jail cell, information about another prisoner, and prosecutors willing to listen. For years, Skalnik presented himself as whatever people wanted him to be: a decorated military veteran, a successful businessman, a police officer, a lawyer, an oil man, even a man supposedly living on borrowed time. Behind each identity was another carefully constructed story, and behind those stories was a skilled conman who understood exactly what people needed to hear. But his most consequential role was not played in a business office, a church or a family home. It was played inside American courtrooms, where his words helped prosecutors secure convictions in dozens of criminal cases. 4 defendants who encountered his testimony were eventually sentenced to death. One of them, James Dailey, remained on Florida's death row as of July 2026. This is not simply the story of a habitual liar. It is the story of what happened when a justice system repeatedly placed its trust in him. The setting was Pinellas County, a narrow stretch of Florida bordered by the Gulf of Mexico. By the late 20th century, places such as Clearwater and St. Petersburg had become symbols of reinvention. People arrived from across America looking for warm weather, affordable living and the possibility of starting again. For Paul Skalnik, reinvention was not a dream. It was a method. In the spring of 1980, Skalnik arrived in Pinellas County because of a wedding, his fourth. His new wife, Suzanne Boggio, believed she had married an ambitious, religious and respectable man. Their wedding announcement described him as a former United States Marine and the general manager of a chemical company. What Suzanne did not know was that 3 women had already been married to him. She also did not know that, when he stood beside her at the altar, he was reportedly still legally married to another woman. Skalnik attended church with Suzanne and spoke convincingly about faith, responsibility and the future they would build together. Soon, he announced another impressive development. He claimed he had been accepted into law school. Suzanne supported the household while her husband supposedly attended classes, studied in the library and prepared for a legal career. He left law books around their home and spoke about assignments that appeared to consume nearly all his time. The performance was convincing because it included ordinary details: late nights, heavy textbooks, missed dinners, explanations that sounded too specific to question. But Skalnik was not attending law school. On May 22, 1981, Suzanne received a telephone call from the St. Petersburg City Jail. Her husband had been arrested on a grand theft charge and needed her to arrange his release. The accusation exposed parts of a second life. While pretending to study law, Skalnik had reportedly been presenting himself as an attorney and pursuing another relationship. Even the diamond associated with one of his promises was allegedly fake. When Suzanne reached the bail bond office, a woman working there gave her a blunt warning: leave him in jail and walk away. Suzanne did not accept the advice. Like many people deceived by an experienced conman, she had already invested trust, time and hope in the identity he had created. Skalnik assured her that the accusation was a misunderstanding and that he would resolve everything. After his release, Skalnik violated the conditions of his bail by leaving the area. He was quickly returned to custody and ordered to remain in the Pinellas County Jail until his grand theft case went to trial. Now his usual methods could not easily save him. He was a repeat offender facing the possibility of years in state prison. The confident businessman, law student and devoted husband had been replaced by an inmate waiting in the Florida heat. Then Skalnik recognized something important. Inside the jail, information had value. Newspapers circulated among prisoners and carried reports about arrests, investigations and approaching trials. Skalnik also worked in the jail's law library, where defendants sometimes brought him warrants, police reports and other legal documents. Because he sounded knowledgeable, prisoners could mistake him for someone capable of helping with their cases. That position gave Skalnik access to facts that an ordinary inmate might never see. One day, he walked to a bank of jail telephones and placed a collect call to the state attorney's office. He said he possessed information about prisoners charged with murder. 10 days before Skalnik's own trial, officials brought him from the jail to the prosecutor's office. There, he claimed that 3 different defendants had made full or partial confessions to him. 3 murder cases. 3 accused men. 3 supposed admissions obtained during one summer. It was an extraordinary claim. Experienced investigators could spend months working without obtaining a single confession. Skalnik said he had received 3 while sitting in county jail. Later research found that some of the details he supplied resembled information already published in local newspapers. In another case, the defendant had apparently shown Skalnik legal documents while seeking his advice. Prosecutors could have treated those similarities as warnings. Instead, they saw a potential witness. They offered Skalnik a plea arrangement. If he admitted the grand theft charge, the state would recommend no more than 3 years in prison rather than the 5 years he faced. Officials also left open the possibility of an even better outcome if his cooperation proved valuable. Skalnik accepted. His sentencing was postponed while prosecutors waited to see what else he could provide. The longer he remained useful, the longer he could hope that his information might purchase his freedom. That arrangement created a dangerous incentive. Every new accusation could become another reason for the state to help him. Every supposed confession could strengthen a prosecution while improving Skalnik's own position. This did not automatically mean that every statement he made was false. Jailhouse witnesses can sometimes possess legitimate information. But Skalnik was no ordinary witness. Deception was not an isolated event in his history. It was the foundation of his adult life. Over the years, he reportedly posed as a fighter pilot, a wealthy oil man, a real estate developer, an undercover federal agent and a criminal defense attorney. He married 9 women, with some of those relationships allegedly overlapping. For more than a decade, he also claimed to be seriously ill. Skalnik understood authority. He understood uniforms, professional language, official documents and the emotional power of an impressive title. He had briefly worked in law enforcement in Texas, giving him additional familiarity with police culture and criminal investigations. Most importantly, he understood that an effective lie does not need to be completely invented. It can be built around fragments of truth. Between 1981 and 1987, according to investigative reporting, Skalnik provided information or testimony in at least 37 cases in Pinellas County alone. 37 cases. That number represents defendants whose freedom could be affected by what he said, jurors asked to assess his credibility and families waiting for verdicts. 4 defendants connected to his testimony received death sentences. Meanwhile, Skalnik repeatedly received favorable treatment. A serious charge involving a child was dismissed. In another period of incarceration, he was granted parole after serving roughly half of a 5-year sentence, despite a correctional assessment warning that he remained at high risk of committing further crimes. Prosecutors sometimes maintained that no formal promise had been made before he testified. That distinction mattered in court because jurors needed to know whether a witness had been offered something in exchange for cooperation. But rewards do not always require written contracts. A seasoned informant may understand that useful testimony can produce future consideration, even when nobody explicitly guarantees it beforehand. Skalnik had learned the pattern: provide information first, then wait for the system to remember the favor. The case that would define his legacy began in 1985 with the murder of 14-year-old Shelly Boggio near Indian Rocks Beach, Florida. The details of Shelly's death were deeply disturbing, but they do not need to be repeated here. What matters is that a young person lost her life and that investigators faced enormous pressure to identify everyone responsible. 2 men, Jack Piercy and James Dailey, were prosecuted in connection with the crime. Piercy was tried first and convicted. Dailey consistently maintained that he had not participated in Shelly's murder. The case against Dailey contained circumstantial evidence, including testimony about events surrounding the night of the crime. But prosecutors had no fingerprint, hair, fiber or other physical evidence directly connecting him to the killing. There was no eyewitness who testified to seeing Dailey commit the murder. What the state did have were 3 jailhouse informants who claimed Dailey had spoken to them. The most memorable of those witnesses was Paul Skalnik. By that time, Skalnik was being held in protective custody because his history of informing could make him a target among other prisoners. He had already supplied information in numerous cases and understood exactly how valuable a supposed confession could be. According to later reporting, Skalnik offered his services to prosecutors in the Dailey investigation before he had even encountered Dailey. Skalnik eventually claimed that Dailey confessed and that he had also acted as an intermediary between Dailey and Piercy. According to his testimony, messages were passed concerning how the 2 defendants might handle their cases. Dailey denied confessing to Skalnik. His defense argued that the alleged conversations had not happened and that Skalnik was once again transforming available information into a story prosecutors wanted to hear. Yet when Skalnik took the witness stand in 1987, he delivered something more powerful than a fingerprint or laboratory report. He offered the jury what sounded like Dailey's own voice, a private admission supposedly made when no police officer was present. That is what makes Jailhouse confession testimony so influential. It appears to come directly from the accused while arriving through a witness who may have strong personal reasons to invent it. During the trial, jurors learned that Skalnik had committed theft and other dishonest acts. But they did not receive a complete picture of his history or the full extent of his work as an informant. Skalnik described his record in terms that minimized its seriousness. The prosecution presented him primarily as a thief rather than a physically dangerous criminal. Years later, Dailey's attorneys argued that Skalnik's description concealed the previously dismissed charge involving a child and created a misleading impression of his background. The prosecutor maintained that Skalnik had received no guaranteed deal in exchange for his testimony. Technically, there may not have been a written promise waiting for him. But the history of his cooperation showed that Skalnik had repeatedly benefited after helping the state. The jury convicted James Dailey of murder, and he was sentenced to death. 5 days after that sentence was imposed, Skalnik received another extraordinary break. Although he was facing a new grand theft case and had previously been described as a flight risk, he was released without having to post bond. No document needed to say that his testimony had been rewarded. The timing spoke loudly enough to raise questions that would continue for decades. Dailey's conviction did not depend on Skalnik alone. 2 other inmates also claimed Dailey had confessed, and prosecutors presented additional circumstantial evidence. That distinction is essential because it later became part of the court's reasoning for refusing to overturn the verdict. But Skalnik's testimony was especially dramatic. It gave prosecutors a detailed narrative and allowed them to argue that the accused had revealed knowledge of the crime from inside the jail. The question was whether Skalnik could realistically have heard what he claimed. Years later, evidence about the jail's layout and protective custody procedures created serious doubts. Chief Judge Ed Carnes of the Federal Appeals Court eventually acknowledged that Skalnik's account was likely false because the physical arrangement of the jail and the restrictions surrounding protected prisoners made the alleged encounter difficult to reconcile with reality. The judge also noted evidence that Skalnik had lied about other matters during the trial. Yet recognizing that testimony was probably false did not automatically overturn Dailey's conviction. The appeals process does not simply recreate a trial from the beginning. After decades have passed, a prisoner must satisfy demanding legal rules involving deadlines, admissibility and proof. A court reviewing an old conviction asks different questions from jurors hearing the case for the first time. Dailey's attorneys argued that no physical evidence connected him to Shelly's murder and that the state's most influential informant had been fundamentally unreliable. Supporters of Dailey's innocence said the remaining evidence was too weak to justify a death sentence. Prosecutors defended the conviction. They emphasized the other informant testimony and the circumstantial evidence considered by the jury. Then Jack Piercy, the co-defendant, complicated the story further. In written declarations, Piercy claimed that he alone was responsible and that Dailey had not participated. But when called into court, Piercy refused to provide supporting testimony and later made statements that undermined the declarations. Florida courts ruled that those written claims were unreliable or legally inadmissible. Without admissible new evidence, the declarations could not produce the retrial Dailey sought. The result was an unsettling divide between doubt and legal relief. Judges could question important testimony while still concluding that Dailey had not crossed the extraordinarily high threshold required to overturn his conviction. In 2021, the Florida Supreme Court again rejected Dailey's claims. The court ruled that arguments concerning Skalnik's misleading account of his criminal history were procedurally barred or insufficiently important to change the verdict. The majority reasoned that jurors already knew Skalnik had committed multiple crimes and that 2 additional inmates had also testified about alleged confessions. From that perspective, revealing more damaging information about Skalnik would not necessarily have produced a different outcome. That conclusion did not establish that Skalnik had told the truth. It meant the court did not believe the disputed information met the legal standard required to reverse Dailey's conviction. As of July 2026, James Dailey remained on Florida's death row and continued to maintain his innocence. Shelly Boggio's family, meanwhile, had lived for more than 4 decades with the consequences of her murder, repeated court proceedings and continuing public uncertainty. Any responsible account must remember that this legal controversy began with the loss of a young life. Skalnik continued moving through the justice system long after the Pinellas County trials. His talent for fabrication followed him between Florida and Texas, as did arrests, false identities and offers to provide information about other prisoners. In 2015, he was arrested for failing to comply with requirements connected to his criminal record. Authorities reportedly found numerous false identification documents and other fabricated materials in his possession. Even then, Skalnik attempted to make himself useful by offering information from inside jail. This time, law enforcement declined. The system that had once welcomed his stories no longer considered him a valuable witness. Paul Skalnik died in 2020. He left behind a trail of broken relationships, fraudulent identities, disputed testimony and criminal cases that could never be viewed quite the same way again. The danger exposed by Skalnik's story did not disappear with him. Jailhouse informants continue to appear in American criminal cases, particularly when prosecutors lack direct evidence of a confession. Sometimes these witnesses provide accurate and important information. But the structure surrounding them can reward dishonesty. A prisoner may receive reduced charges, improved living conditions, early release or favorable recommendations. If those benefits are delivered only after the testimony, the witness can truthfully tell jurors that no reward has yet been promised, while still expecting one. Defense attorneys may struggle to discover how many times an informant has previously cooperated or what assistance followed earlier testimony. Without a central tracking system, one prosecutor may not know that the same person has claimed to hear confessions in numerous unrelated cases. Skalnik demonstrated how far that weakness could be exploited. Each successful appearance increased his experience. He learned what investigators asked, what jurors found persuasive and how prosecutors described cooperation in court. The justice system believed it was using him. But it is equally possible that he was studying how to use the justice system. His story also reveals why credibility cannot be reduced to a simple question: does this witness appear confident? Experienced conmen often appear confident. They maintain eye contact. They remember selected details. They speak in the language of whatever profession they are imitating. Their effectiveness comes from understanding that most people expect deception to look nervous, inconsistent and obvious. Skalnik's lies were effective precisely because they often looked organized. He surrounded falsehoods with real names, actual court documents and publicly available facts. If challenged on one detail, he could redirect attention to another that investigators already knew to be correct. In an ordinary fraud case, that talent could cost someone money. Inside a murder trial, it could cost someone the rest of his life. There is no reliable way to examine every case touched by Skalnik and declare that every defendant was innocent or that every statement he made was fabricated. Some convictions included independent evidence. Some defendants may have spoken to him. Some of his information may have been accurate. But that uncertainty is not a defense of the system. It is the problem. When one witness supplies information in dozens of cases while repeatedly receiving personal benefits, officials should document every interaction, disclose every reward and examine every previous claim. The more useful a witness becomes, the more carefully that witness should be investigated. In Skalnik's case, usefulness frequently appeared to outweigh scrutiny. Prosecutors knew he was an accomplished fraudster, yet they returned him to the witness stand again and again. They asked jurors to believe that a man who deceived wives, employers, businesses and courts had suddenly become trustworthy whenever another person's conviction was at stake. Perhaps that was Paul Skalnik's most successful deception. Not the fake military career. Not the imaginary legal education. Not the overlapping marriages, false documents or invented illnesses. His greatest deception may have been convincing powerful institutions that his talent for lying could be safely controlled, that he would deceive everyone except the prosecutors offering him a path toward freedom. The unresolved question is not whether Paul Skalnik lied. His documented history answers that. The question is how many of his courtroom stories were false, how many verdicts were shaped by them and why so many officials were willing to accept the risk. A justice system cannot promise perfect certainty. Witnesses make mistakes. Evidence can be incomplete. Courts must often decide cases using conflicting accounts. But when freedom, or a human life, depends on the word of the witness who benefits from conviction, doubt must not be treated as an inconvenience. It must become the center of the investigation. Paul Skalnik spent decades pretending to be someone he was not. Yet the final and most disturbing part of his story is that he never performed alone. Every courtroom appearance required officials to place him on the stand. Every deal required someone to approve it. Every missing disclosure required someone not to ask another question. And somewhere between the jailhouse, the prosecutor's office and the jury box, a conman's words became evidence. What do you believe? Should testimony from a rewarded jailhouse informant ever be enough to help sentence someone to death? Share your opinion in the comments. And subscribe for more carefully researched true crime documentaries examining not only the people accused of crimes, but the systems responsible for deciding the truth.